Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Robert E. Temmerman Jr., who I'm just going to call Bob. And Bob is an attorney specializing in estate planning, incapacity planning, and estate and trust administration. He is a partner and founder of Temmerman, Silly, and Coleman, LLP in San Jose. Bob received a BA in Economics and Political Science, magna cum laude from Boston College in 1975, and his Juris Doctor degree, magna cum laude from Santa Clara University in 1980. He is an active speaker in the estate planning community, including recently he spoke at the Jerry Kasner Estate Planning Symposium, which is presented by the University of Santa Clara here. And he also speaks for our Estate Planning Council, bar associations, other estate groups around the country. And he's also contributed chapters to books, including California Estate Planning, which is published by Continuing Education of the Bar. Bob has also participated in writing rules of the court for the Santa Clara County Probate Court. On a personal note, Bob is quite an athlete. He just completed a 2-month bike trip across the United States, and he also plays amateur hockey. I know you do some kayaking and just lots of other sports. Anyway.
It's the fun stuff, Mike. I live for the fun stuff.
Good for you, Bob. Go for the gusto, carpe diem, and all that stuff. Anyway, today our subject is, I'm a trustee, now what? And before we get started, I just want to caution you that we're discussing administering a trust after a death, and other considerations will apply for other scenarios like special needs trusts. And also that we want you to consult with an attorney when you're administering a trust. This is just an introduction, part of what we hope will be an ongoing conversation that you're going to be having. It's a huge topic. Bob has spent years studying this stuff. We're not going to cover it in 28 minutes. And also, we're discussing administering trusts in California. The laws in other states may be different. So with that, off we go. Okay, Bob. First of all, thanks for joining me today.
My pleasure. It's always good to see you, Mike.
And it's a real pleasure having you. All right, so some people think that since they made a living trust, nothing special needs to be done when somebody passes away. Is that right?
That's a common misconception, Mike, that oftentimes living trusts have been sold, and I'll use the word sold as opposed to explain to a client, that if you have a living trust, there's no need for any sort of probate or court supervision following death. And the answer is yes, that may be true, provided that the assets that have been fully transferred into the living trust, there might not be a need for court supervision, but there's still a need for administering this trust in a post-death context. There's still a need for having a successor trustee assume the role following the death of a settlor. The settlor is the person who created the trust, who is oftentimes the initial trustee. So the same rules that apply in probate, the general rules of collecting the assets, paying the decedent's debts, and ultimately distributing the property still has to occur. Mm-hmm. And it doesn't have to occur necessarily under court supervision, but that doesn't mean that it happens like that. Mm-hmm. So there's still a need for what we would call trust administration.
Yeah, I'm trying to remember when this happened, but I had one of the clients, actually I was administering or helping out with a trust where father had passed away, and then I'm looking at some of the assets that he had and so forth, and it turned out that grandma and grandpa had passed away, 30 years ago, and their stuff hadn't been taken care of.
We actually, you laugh, but that's actually fairly common. We've administered multi-generational trust because no action was taken at the first death. And for the family homestead, if the survivor is living in it and then the only child is living in it and no one is kicking you out of the house, there's not a real big incentive. But there are needs to be taken care of and addressed. So if you're named as a successor trustee under a family member's trust or under a neighbor's trust or a friend's, I would encourage all your viewers to make sure they consult with an attorney to determine what are some of the steps I have to take, because there are a number of steps that need to be taken.
And remember to let the successor trustee know that they're a successor trustee.
True.
All right. Now, if the decedent had a living trust, does that automatically mean that no probate is required?
Not automatically. In most cases, no court supervision will be necessary. But in some cases, and in some cases where there is a dysfunctional family, some sort of court supervision may indeed be warranted. The most common example of why I might need some court supervision is that not all the assets got transferred to the trust. For instance, if mom and dad created a trust, but they failed to leave a vacation home or failed to transfer the vacation home into the trust, we may have to actually probate that asset. There are some shortcuts that we can try and take in order to avoid having a full-blown probate, such as filing a petition with the court saying it really was mom and dad's intent that all of their assets be put in the trust. And that intent can be manifested in sometimes what's referred to as a schedule of assets that we want put into the trust, even though they weren't formally transferred. The best advice is if you do have a trust, make sure that the assets that you own are in fact in that trust.
Okay. Now, well, I guess we sort of brought this up. Is it unusual for families to neglect the formalities of administering trusts after a death, and what sort of consequences might come from such a failure?
The failure is going to occur more where there aren't immediate family members. There might be distant relatives, siblings, or more distant relatives, nieces and nephews. In a situation where there's a spouse or there's children, typically we're not going to, or we're going to administer that trust. The key points to any sort of administration are finding out what are my responsibilities. I'm a trustee. What do I have to do to carry out the intentions? And we start with the four corners of the document. What does the trust actually say? Who are the beneficiaries? Are there any special provisions in our governing instrument that we have to be aware of to make our trustees aware of them?
Okay.